everybody. My name is Debbie Schlossberg, Patient Services Coordinator in New Jersey for the ALS Association Greater New York chapter, and I'm thrilled to welcome you all this afternoon, evening, for a workshop with Shana Siegel. Shana Siegel concentrates her practice in the area of elder law, focusing on representing seniors, individuals with special needs, and their families in connection with life care planning, public benefits, trusts and estate planning, and long-term care advocacy. As one of the few certified elder law attorneys in Northern New Jersey to be certified by the National Elder Law Foundation, Shana has extensive experience in probate and estate administration, asset preservation, supplemental and special needs trusts, planning for disability, guardianship and estate litigation, resident rights, healthcare decision-making, Medicare, Medicaid, and health insurance appeals. Prior to joining Norris McLaughlin, Shana was with Wanderpolo and Siegel for over 10 years, 5 of which were as principal. Additionally, Shana is a member of the New Jersey Women Lawyers Association, the New Jersey State Bar Elder and Disability Law Section, and the Life Care Planning Law Firms Association. Shana is active with the Long-Term Living Association, several local chambers of commerce, and Jewish philanthropies. And it is my honor and pleasure to share Shana with you this evening. And she has a wonderful presentation. Shana, take it away.
Thank you so much, Debbie. I always appreciate the opportunity to speak with your organization and to get out, even if it's kind of virtually here, and get to know people and hopefully provide some much needed education. So I appreciate that. There's a lot of information on the internet and sometimes not always applicable as in our state, or really gives you the full picture. So hopefully you'll have a really good sense of these issues when we're done. All right, so I wanted to start with a positive. I wanted to start with a win that the ALS advocacy community had in 2020. You may be aware of this. The ALS Disability Insurance Access Act eliminates the 5-month waiting period for SSD benefits, which is wonderful because obviously that 5 months can make a huge difference in people's lives. And that allows for retroactivity all the way back to onset or filing. I know that gap has really been a problem for people. They've looked to SSI or Medicaid to fill in during that period. And so this can really be very helpful for people. So in terms of thinking about why people plan, why people fail to plan, when you have a diagnosis like ALS, obviously you're dealing with a lot of issues. You're potentially overwhelmed, potentially, really having a difficult time coming to terms with that diagnosis. And there's just so much going on. I think with ALS, there's also another component, which is, really why I wanted to mention here, is many people think that planning won't help. They think that, there's 5-year rules. They've heard all kinds of things about, that there's really nothing that they can do to protect themselves. And that's not necessarily true. So that's one of the reasons I like to get out and talk about what is available. So I want to start off talking a little bit about estate planning generally. I think it's really important for everyone, regardless of health issues, to undertake in their estate planning, to appoint a power of attorney and a healthcare proxy. But obviously that's all the more important when you're dealing with a diagnosis of ALS. I think it's really important to outline your healthcare wishes. Consider what you would want at various points in the disease process. And obviously that may change as you're going through the disease process, but it's important to really outline those wishes and share them with your family members and your medical team so that they know what you want and that it will be respected. It's really about empowering yourself doing your estate planning, and particularly when we're dealing with documenting our healthcare wishes. Your estate planning is also obviously very important to protect your family by proper planning. If there are assets that are not handled properly, we see all kinds of issues and things going not the way you want. And we really want you to be able to have your assets be distributed to the individuals, organizations that you want them to go to, not what happens automatically by default. So important to make sure that that's going to happen, and that you didn't maybe miss something that you didn't realize. There are a number of different types and approaches to a power of attorney, but generally, when you're looking at a power of attorney, you're thinking about, who do I want to be able to step into my shoes? If there comes a point where I am unable to handle my banking, or I'm unable to get on the phone and have conversations as easily with insurance companies or former employers or government agencies. You want somebody who's going to be able to handle all of those things for you. It's also important that you give them the tools that they need to be able to act. So that's not just the document, which we're going to talk about, but also all of the underlying information that's in your head that they need to know. So where your accounts are, what medicines you're on, who your physicians are. If you're not sharing that information with your family members, then they're not going to be able to act in your interests and follow your instructions. In terms of types of power of attorney, people ask me, well, can I do this? Can I do that? You can really do anything that you want. This should be a document that reflects what your wishes are and what your priorities are. And that may, that may mean that you have a somewhat non-standard document. That's okay. We generally look at two different types of powers of attorney in terms of when they are effective. So we have what is an immediate power of attorney, but it's generally called a general durable power of attorney, and that is effective immediately. So that means at any point, your agent could act on your behalf. That compares with a springing power of attorney, which requires a finding of incapacity. Usually the documents will say that two physicians have to state that you're unable to handle your own financial affairs, and that therefore that individual can step in and act for you. I generally recommend that you go with the route of the immediate, because we don't necessarily want to have to get two physicians, and it's not always black and white, right? It's not flipping a switch. You don't go one day you're perfect and the next day you're not. So I find that in that gray area, it can be really useful to have the general durable, but there are some situations where you might not want that. So that's a conversation to be had with your counsel. You can do a general power of attorney, as we've talked about, or you could have more limited powers for specific accounts or for particular tasks, such as for selling your home, for applying for Medicaid. You could have something that's much more limited in scope. And you might do that also if there's a number of different individuals who are going to help you with different tasks. One thing, many people think, oh, well, I have a power of attorney. I did that 10 years ago when I did all of my other documents. But the power of attorney that you may have, first of all, if it's old, you may have trouble getting it recognized and accepted by a bank. Secondly, it may not have a gifting power or a broad enough gifting power. So when we talk about asset preservation, one of the things that is often involved is moving your money. Whether that's into a trust or to your children or to your spouse. You need to have a gifting power in your power of attorney to be able to do that. So you want to take a look at that language and make sure that it really meets what your needs may be looking into the future. Many people think, well, I don't need a power of attorney because I have my assets held jointly. And I'm not talking about here husband and wife. I'm talking about more like you put a child onto your bank account and say, that they can handle it because they're on that bank account. But what many people don't realize is if you choose that approach and you put someone on your bank account, that means they inherit that account. And that may not be what you want if you have, for instance, multiple beneficiaries, and now all of a sudden you have one account going to one person instead of being split amongst your beneficiaries. So just something to consider. Healthcare decision making. So, as I said, I always tell my clients that I think your healthcare decision making documents are really the most important because they're the most personal, and they're dealing with what really matters. What's going to happen to us, right? Money is one thing, but what's going to happen to us is really what most people are ultimately concerned about. So there are a variety of different documents, and we're going to talk about each of them. I think we're going to talk about each of them. Okay, let me just run through them here. So we have a healthcare proxy. So a healthcare proxy is a document in which you're going to name your agents who are going to step in and make healthcare decisions for you. You can have a separate instruction directive, which I often recommend because you can go into more detail then. And there you're going to state what things you might want at various points. We have a HIPAA document, so you may want to give all of your family members access to information, even though each one of them isn't able to make decisions on your behalf. And then we have a practitioner order on life-sustaining treatment, which we'll talk about. All right, so let's talk about estate planning goals. So why do I want to do my estate planning? Well, we've talked about this a little bit. We've talked about controlling who gets your assets. You want to make sure that you decide that and not the state. Perhaps controlling how they use their money. So, for instance, we want to make sure that you're going to have, if you have children who are minors or young adults, when and how they get access to the funds. You might have other individuals who you feel you need to make some provision for, perhaps in a trust, as to how they are getting access to the funds, how distributions are being made. You may want to do estate planning that focuses on minimizing taxes. In New Jersey, we have a variety of different taxes, as I'm sure you all know. We don't have an estate tax anymore, so that's one tax that has gone away, but we do have an inheritance tax, and an inheritance tax is applicable when your beneficiaries are not either your spouse or your direct bloodline, so not children or grandchildren. If you are leaving your assets to siblings, nieces, nephews, friends, then they're going to pay an inheritance tax. So that may be something that through planning, you could potentially minimize that somewhat. A lot of the tax planning that we do focuses right now on income tax and capital gains issues. So there are things that we can do in order to minimize the tax that would be paid by your beneficiaries ultimately. Many people are concerned about avoiding probate, and we're going to talk about that in a minute, whether that's a real concern or that's something that is, less of an issue. Of course, we're very concerned about protecting our legacy in terms of protecting from costs of long-term care. You've worked very hard all your lives, and now you want to make sure that you're able to pass assets on instead of having all of your assets used on the cost of your care. And then there's legacy issues, whether that means that you want to share your viewpoints, your ethics, or whether you want to, pass on assets to charities or, throughout generations.
Can I just jump in 1 second? I see that there's so much information here. I just want to mention, which I neglected in the beginning, that if anybody has any questions, feel free to enter them in the Q&A and we'll get to them at the conclusion of Shana's presentation. Sorry, back to you, Shana.
No problem. So When we mention about avoiding probate, a lot of clients tell me, I need a revocable living trust, and I need that because I have to avoid probate. And there are many good reasons for having a revocable trust. We're going to talk about some of them, but not necessarily avoiding probate. In New Jersey, probate is a very fast and easy process. Slightly less so during COVID, but that's gotten better too. And it's really just a matter of having the will taken to the surrogate, having it a document be issued that allows the executor to act. So it's not a major a process or a major expense. Using a revocable living trust in order to avoid probate does not avoid any of the taxes. It does not avoid inheritance tax. It doesn't avoid any income tax, or even when we had estate tax, it didn't avoid that. So that's something that people don't necessarily understand. Now, you might still want a revocable living trust. Some people have concerns about financial management. They have concerns about they don't necessarily have somebody close to them, but they want to make sure that they have a document that states what their wishes are and how that person, their trustee, should be able to use their funds for their benefit. So in that case, a trust might be better because you can get into more detail than just in a power of attorney. Individuals who have out-of-state property can be very useful to have a revocable living trust, because probate in New Jersey might not be bad, but if you have to also have probate in New York or Florida or Pennsylvania, then that can become very difficult. So you can avoid that with a revocable living trust. Simplifying extensive holdings. So I've had clients who have many, many bank accounts and or brokerage accounts, and they want to make it very simple for the person who's going to step in and act on their behalf. That one way to do that is through a revocable living trust. Some clients are concerned about privacy, and so that is something that you do get by avoiding probate. Having quick access to funds after death. So for instance, if you have a child or a spouse who's going to need access to that money right away, spouse often will have that access through joint accounts, but a child might not. So that might be some place where you want to make sure that you do a revocable living trust. And if you have a situation where you're concerned about a will contest, a revocable living trust might be a better option for you in that scenario. So it's really all about looking at your particular situation and deciding whether it makes sense for you. So there are certainly many other types of trusts. Just to very quickly touch on them, and we're going to talk a little bit more about special needs trusts. So there are special trusts that are used for Medicaid asset protection. We'll talk about that a bit. You can use a trust for financial management. You could put your IRA into a trust. So for instance, if you want to make sure that you're passing it on to someone to make sure that they don't just take it outright. This is a little bit different in terms of the stretch provisions now, but this is still applicable for certain people. Disabled family members still have that stretch over time. If you're looking at protecting minors or vulnerable adults, you might want to do that through a trust. We certainly don't want to leave our assets to minors because they're not going to get it. So we really would need a trust in that situation. And I consider anyone who's kind of in their 20s may make sense to have a trust, because they're just not quite ready to be able to manage those type of funds. Trust can provide creditor protection, which can be important for those beneficiaries. Special needs trust, which again we'll talk about extensively, and this second marriage. Sometimes you may want to make sure that you're providing for your spouse, but you want to make sure that those assets will ultimately go back to your children if something happens to your spouse or if they remarry. And then, of course, for a variety of tax planning, as we've kind of touched on. All right, so let's talk about understanding special needs trusts. So many people are not quite sure whether or not a special needs trust is right for them and whether it's something that they absolutely need to be doing or whether it's something that they should just be considering as an option. Well, first of all, there's really two categories of situations that a trust is very helpful in the special needs context and the disability context. First is for asset management. So you might want a trust so that there's someone who is able to manage those assets for you, a trustee who is in charge of handling those assets if there comes a point where you're not able to do so anymore. But typically, we see special needs trusts are done for the purposes of qualifying for public benefits. But it's really important here to make the distinction that we are talking about public benefits that are means tested. So if you are on Social Security disability, if you are on Medicare, those are not means tested. It doesn't matter how much money you have. So you don't have to have a special needs trust in order to qualify for those benefits. You may know that. You may already be on those benefits. But if you are looking to be on Medicaid, for instance, to pay for long-term care costs, as we're going to talk about, those do require that is a means tested. And so a first party trust might be part of the plan that you undertake. It's important to think about, though, when you're putting money into a first party trust, if you have spouse or other family members, you really need to think about and talk to a professional about how I'm balancing my needs under that trust with the needs of whomever those beneficiaries are. Because if I put my own money into a first party special needs trust and I don't use that money during my lifetime for myself, that money's going to end up going to the state. So we want to be very cautious about not overfunding that trust. Now, a third party trust is different. That is a trust where it is funded by someone else. So another family member is going to leave money to you. You would want them to leave that money in a third party trust. And in that scenario, those funds do not go to the state after you pass. So I could leave money for my child or for my sibling in a third party trust. If that beneficiary passes away, then those funds can go somewhere else to another beneficiary that I want to name. If I'm creating a third party trust, I can do that in my will, or I can do it as a separate standalone document, a trust that I might fund, during my lifetime. Okay, so I know that one of the main concerns is thinking about the cost of long-term care. So just to give you a sense, if you have not experienced any of this yet, home health care costs vary greatly, but particularly if you're working with a private aid versus working through an agency. But we are really starting to see hourly pay rates that are in the $20 to $25 an hour range. Even working with private aids, you're finding $18, $20, $22 an hour. So can really add up very quickly. Assisted living, huge range here, anywhere from about $4,500 a month up to $10,000 a month. And that's really based on level of care needs, because assisted living really can manage a very wide range of needs and levels of assistance, levels of care. A skilled nursing care is where you're really going to need a higher level of care, and particularly more of a medical piece. So where there may be a trach, maybe an individual who's bedbound. At that point, you're going to be looking at a skilled nursing care setting, and that would be in the $12,000 to $15,000 per month cost. So what are some of the sources to pay for long-term care? Well, we may be looking at Medicare, and as you may know, there's a very, very limited coverage under Medicare for long-term care, really post-hospitalization, very limited. Private pay, long-term care insurance, if you had that policy prior to diagnosis, veterans pension, which we'll talk about, and Medicaid, which we will, of course, talk about. So I like to point out, because a lot of people don't know that veterans benefits can be very important for assistance for individuals, veterans who have ALS. There is a presumptive eligibility for service-connected compensation for the compensation benefit. So, if you are a veteran, you really want to get with the veterans organization or with an attorney that specializes in this area and find out if you qualify. Because you may very well be able to. There is also a special compensation add-on for ALS. So it really could be a substantial amount of funds that you could be entitled to as a result of your service-connected compensation. Even though you might not think of it as a service-connected disability, it is considered that way for veterans in many cases. If you need assistance with your activities of daily living, you need assistance with 2 activities of daily living at the point that you would then qualify for the benefit. And the benefit is a cash benefit. And again, depending on whether you're service connected, it's at a certain range, or if it's not service connected, then it would be at a smaller amount, depending on what your care costs are. It's really important, if you're looking at the veterans benefit, and potentially coordinating that with Medicaid, because you can get into a situation where you've put all this energy into doing the veterans, and then it's not enough to cover your care, and then all of a sudden you need to go the Medicaid route. And they do have different rules, they do have different eligibilities, and they have different rules with regard to, for instance, special needs trust and annuities. So you really want to kind of think of those things ahead of time if you're looking to coordinate the 2 programs. There are veterans facilities in New Jersey that will also provide on a sliding scale and provide services. And there are programs, for instance, there's home care that is provided. That may be something that would be available to you, early on your diagnosis, before you needed, a higher level of care. Might be just, a few hours of nursing that you could get through this veterans program might just be perfect for you. So I'd really look at that. There's also all kinds of programs with regard to home modifications and some of the durable medical equipment that you might need in the home. So really good, if you are a veteran, to make sure that you're aware of all of the things that are out there for you. All right, let's talk about Medicaid, because this is where there's often a lot of confusion. Well, Medicaid is a means-tested program. So that means that there's financial rules that apply, both with regard to income and resources, as we'll get into in more detail. It's funded by both federal government and the state government, and it can provide skilled nursing care, either in a skilled nursing facility, in an assisted living, and also at home, so home care as well. The home care is a little bit limited. It's, you're not going to have somebody living 24 hours, but it certainly is, can really be a huge help when there is a caregiver in the home who needs that respite, needs the ability to get out and do things. So having that home care can really make the difference in whether or not, you could stay at home. When we're looking at that financial eligibility, so the applicant, we're not talking about the spouse here, we're going to talk about that in a minute. If there is a spouse, the applicant can only have $2,000 in their name. In terms of income, a lot of people say to me, well, I could never get Medicaid because, I have good income. I have my Social Security disability, or I'm still getting private disability from work. And so I would never be eligible. And that's not necessarily true. So as your income can be as high as your cost of care. So if you have care costs that are $10,000 and you have $6,000 of income, you could still be eligible. You will have to contribute that income in, or at least a substantial portion of that income, towards the cost of care. And then Medicaid will pay the amount above that. And you see, I reference here a QIT, which is a specialized trust that we used in order to put those excess income in, but it does not mean that you're not eligible. And in some situations in that qualified income trust, your income can go for other things. So for instance, if you are going to be living at home, not all of your income has to go to cost share. Some of it can go to your living expenses. Or if you have a spouse, you might be able to direct some of your income to the spouse. So that's what that qualified income trust is for, is to designate how that income is being divided amongst the various obligations. In terms of exempt resources, the primary one is your primary residence, and that's going to be exempt as long as either the applicant or the spouse are living in the home. You can also create a funeral trust, which is essentially means you're going to prepay your funeral. You can put assets into that, and that way they are not considered for Medicaid purposes. You can also put in personal property. You can also have exempt personal property. So your jewelry, your car, variety of, all your personal stuff isn't considered for Medicaid purposes. There are caps officially on the books. There are caps on that, but it's never an issue in terms of applying for Medicaid. So it's not as if they're going to come in and say, oh, your diamond ring is too much money, or your, piano that's in the house. That's not an issue. And then another exempt resource is that first party special needs trust that we talked about. So if you have a spouse, the non-applicant spouse is able to retain up to 1/2 resources. But there's a cap on that. The cap is 130,380. So, and that changes annually. So that means that if you have $250,000 in, savings, then your spouse is able to keep 125 of it. If you have $1 million, your spouse is able to keep 130,000 of it. Now, before you get too upset, we're going to talk about what else can be done. This is prior to planning, right? So prior to planning, Medicaid thinks that 130,000 is sufficient for the community spouse for their savings, which obviously is exceedingly problematic, which is where the planning comes in. So as we mentioned, if you have income and it's over that cap, which isn't really a cap, which this year is 2382, then it has to go into that qualified income trust, as I mentioned. And from that trust, other things you might be able to have assets that go out to the community spouse. You might be entitled to giving them their income, giving them some of your income. In addition, the community spouse retains all of their own income. So if you are married to someone who has a very good salary and they are still working, that's okay. Their salary is completely irrelevant for purposes of your eligibility for Medicaid. So that is, a relief to many people who don't realize that. They think that the income is looked at jointly, just like the resources are. Now, because we have this rule that a community spouse can retain all of their own income, as a result of that opens up some planning opportunities. And one of the planning opportunities is conversion of resources to income. So if I have $200,000 and I have it sitting in an IRA, and that is considered available, whether it's mine or the spouse's, it doesn't matter. That's considered available in New Jersey. However, if I purchased a specialized annuity product with that IRA, it's still an IRA, but it's an IRA annuity with certain special terms. That now is no longer considered a resource. It is now considered an income stream. And if it's my spouse's money, it's the community spouse, the healthy spouse's money, or it's money that the applicant gave to the community spouse in order to fund this annuity, it now belongs to that spouse. And so it is now their income stream, which means that it's completely unseen for Medicaid purposes. So we could take $200,000 off of the resource side, and now it is not considered for Medicaid purposes. So that's a real advantage in terms of being able to up that amount that the spouse can keep in their name. And I use that 200,000 just as an example. It certainly could be, any amount. Transfers. So Medicaid, as I've said, is a means-tested program. And so it's a situation where the Medicaid agency thinks that, we don't want just anyone to be able to give away their money and then become eligible for Medicaid, right? That would kind of defeat the purpose. If I had $1 million, I gave it away yesterday, and now all of a sudden I can go on to Medicaid. So the way that Medicaid looks at it is they have a look back period. You may have heard about the 5-year rule. So they will look at all assets, all resources that you had within 5 years. They literally ask for 5 years of financial statements and ask about any transfers or gifts. If there are transfers or gifts that are substantial during that period, then they will apply a penalty period. And that penalty period, they will say, is a time frame during which you are not ineligible. So for instance, if I gave $10,000 towards my child's wedding, that would make me ineligible for 1 month. If I gave $20,000, that would make me ineligible for Medicaid for 2 months. So that obviously can be very, very difficult in the scenario of dealing with something like ALS, which it can be a quick onset. You may not have had any idea that you had this illness, or you didn't have a diagnosis 3 years ago when you made these gifts to your child, your whomever. There is a situation where you can overcome the presumption that you made this gift for Medicaid purposes if you can show that at the time you made the gift, you had no knowledge that you had this diagnosis, if you had no knowledge that you were ill. In that situation, you may be able to not have a penalty period apply. However, if you continued to make gifts afterwards, then of course they would apply that penalty period. So as I mentioned, annuities are products that can help us in a variety of ways in our Medicaid planning. So they can protect the spouse, as we've talked about previously. They are considered an income stream and not an asset. So we can move assets off of the table and make them into an income stream for the spouse. And that's also can be really important to provide income for the spouse. So for instance, as I mentioned, the applicant's income has to be applied as a cost share. Well, most of us need our income from both ourselves and our spouse just to run our household, to pay our crazy New Jersey property taxes. So having that loss of spousal income can be a huge detriment. And this is another way of, kind of replacing that income is through the use of annuities. If you have made gifts previously, you can potentially address those gifts through the use of an annuity, and you might be able to make additional gifts or make gifts. Maybe you didn't make any in the previous years. You may be able to make additional gifts even if you don't have 5 years. So for instance, normally when clients come to me and they're, fairly healthy, they're in their 60s or their 70s, and they are thinking about Medicaid asset preservation, we talk about a 5-year plan. So because Medicaid looks at 5 years of statements, we may move money out of their name into a trust to their children, and then we wait 5 years. And we're saying, okay, you're going to pay for whatever care you might need in the next 5 years. And hopefully you don't need care. If you do, hopefully it's not going to accelerate. And so you are able to do a 5-year plan. When you're dealing with ALS, that may or may not be an option for you depending on your disease progression, the type of ALS you have. And so even if 5-year plan is not an option for you, you may still be able to do gifting, may still be able to preserve assets for your family members through the use of an annuity product. So some transfers are exempt, some don't apply. There are no penalty results as a result of them. So let's talk about those a little bit. So first is transfer between spouses. Okay, so I can give my anything, any money that's in my name, I can give to my spouse. It's not considered subject to a penalty for Medicaid purposes. Now, remember, it doesn't necessarily help us. If it is liquid money, it's not going to help, right? I'm going to transfer it out, but it's still going to be considered because they look at both sets of assets. But we might transfer it in preparation for doing an annuity, or we might transfer, for instance, our equity in the house, for instance. And we'll talk about the house in a second in more detail. Transferred to a disabled individual. So you might have a family member who you want to benefit. Maybe you have a child who has some special needs that you want to make sure is provided for. And you can make transfers to any individual who is Social Security disabled and without any penalty applying for that. You can do it outright to them, or you could do it to a trust for them. We talked about before, first party trust. This is where you would do this, a transfer by a disabled applicant into a self-settled trust if you're under 65. I don't know if I mentioned that earlier, and it's very important. You can only transfer your assets into a first party special needs trust and preserve them for Medicaid purposes if you are under 65. So that's something that is only available in that situation. Transfer for value. I like to add this because sometimes this may work to our advantage. So, for instance, Medicaid is looking at gifts. They will consider something a gift even if you undervalue it according to their terms. So, for instance, you can't give, a house to someone for $200,000 if it's worth $500,000. However, the way Medicaid determines whether a house is worth $500,000 may not be the market. So they may look at, for instance, the tax assessed value, which may be very different than the actual market. So that might be an opportunity to take advantage of gifting something to someone for a reduced amount. Similarly, life insurance policies, they look at the cash value, not at the death benefit. So you might have a situation where you can transfer out if someone purchases a policy for the cash value, and then they get they're getting that much more valuable policy, which has much higher death benefit. So those are just a couple of examples of being able to use that transfer for value based on Medicaid value. Home. So as I mentioned, you can transfer your home to your spouse. And that's important because even though it's exempt for Medicaid purposes, it is not exempt if you were to pass away. So if you were on Medicaid and you pass away and you own a portion of the property, then Medicaid has a lien against it for your portion. Also, if your spouse were to sell that property down the road and you still owned a portion, that would come back to you in terms of being an asset for Medicaid purposes. So I always recommend that we move the house out of the name of the applicant and into the sole name of the spouse. And there's no 5-year look back or any issue in terms of doing that. You can do it the day before you apply for Medicaid. Some of the other people who you could transfer a home to without penalty, a minor child. a child with a disability, or really actually anybody with a disability. A caretaker child, there are very specific rules that apply to this. But if you do have someone who is going to provide services to you, who is your child, and they're going to provide services to you for a period of 2 years, that keep you from needing a higher level of care, going into a nursing home, for instance, they may be eligible to receive the home without penalty. So that's an important thing to be aware of. I run across this last one fairly often too, which is a sibling with equity. So, for instance, if you inherited a property with your sister, your brother, you can transfer your portion to them without Medicaid penalty. So that's another option that's available to you. So we ran through a lot of information very fast. I never got back around to a pulse. So if anybody has questions, or if you're not familiar with what a pulse is, we can talk about that in the Q&A. But I'm going to turn it over and see if anybody has any other questions.
Thank you so much, Shana. We do have a few questions here. And as you mentioned, if anyone does have more questions, please feel free to enter those in the question box, and we'll be happy to answer them for you. So first question, could you elaborate a bit more about the allowance to spouse from a QIT, from the qualified income
Yes,
test?
yes. So Medicaid has a calculation as to when they believe that the spouse has sufficient income for their own needs, versus when they think that they don't have sufficient income, in which point they're entitled to an allowance from the applicant spouse. So if you have very high income, then you're not going to be entitled to anything from the Medicaid applicant. But if your income is, Social Security, it's, under, let's say, $3,000, then you may very well be entitled to income to be directed from the ill spouse, the Medicaid applicant spouse's income. And that's going to depend somewhat on what your expenses are. So they are going to look at your expenses. There's a formula that they use to figure it out, and they'll bring you up to what they consider kind of like a maximum income amount. It's general. It's not really generous, but at least it is, it really can be life-changing for people who have very limited income.
Super. Thank you so much for elaborating on that. And then our next question here is, you mentioned IRAs, but how are 401ks considered?
Yes. So in New Jersey, 401ks, IRAs, all retirement assets are all considered available, whether they belong to the applicant or to the spouse. That is a big difference between New Jersey and New York and Pennsylvania. I've literally counseled clients and discussed with clients whether or not they might be interested in considering a move, because it is such a major difference. Because in New York and Pennsylvania, that is not the case in most situations. Not all, but in most situations, those are not considered available assets, or certainly the spouses are not considered available assets in those other states.
Wow, thank you for mentioning that. And our next question here, if primary home is already an exempt asset, how does it help to transfer it to a spouse?
So the reason to do that is because, first of all, you want to give your spouse the flexibility that if they later want to downsize, they can, without it impacting your Medicaid benefit. And second is that if the applicant were to pass away and the home is owned jointly, then Medicaid does have a claim against that portion of the house. They're not going to kick a spouse out, but they are going to have a lien, so that's going to impact the ability of that spouse to either sell the home down the road or pass it on to the next generation.
Thank you. And I see we have about 12 minutes left here of our session. I want to check in with Debbie to see if she has any further questions or remarks that she'd like to bring up, or if anyone wants to enter anything further in the chat here. Otherwise, I'd be happy to let everyone have a chance to grab a refreshment or use the bathroom before our next session. So, Debbie, did you have anything else to add in here? Oh, sorry, go ahead, Shana.
I'm sorry, Debbie. I did just want to mention, because I did did kind of skip over Pulse, and I wanted to take a second to talk about that,
Yes.
because if you haven't had that conversation with your medical professional, you really should. It's a practitioner's order on life-sustaining treatment, and it's essentially taking your advance directive or your living will and making it a medical order, because it's signed with your nurse practitioner or with your physician. And so it is much more easily recognized than just a living will would be. So it's going to be recognized in the emergency room, even by paramedics. So it's really something that, it's a good idea to do, and you can change it as, as your disease changes, or as your ideas about what your wishes are change. So it's a really useful tool, I think, to be able to continue to have that autonomy and that control over what your what your treatment looks like.
So all I just would want to add is that there are a couple other programs in New Jersey that are administered county by county that provide modest benefits, home care benefits.
Yes, absolutely.
But they too are means tested.
Yes.
They're a bit easier. Well, they're far easier to qualify for than Medicaid, but you also get far less. So, I think any way we look at it, and I know that families discuss this with me on a daily basis, planning is important. Whether you have a lot or whether you have a little, or like most of us, something in between, planning is really, really critical. And one of the very first things that Shana said, when she mentioned Medicare, it could be because the words are so similar, Medicare and Medicaid, but people constantly think that Medicare is going to provide all these things that it doesn't. It really, really doesn't. So it has been a huge victory for us that we've been able to accelerate Medicare and Social Security for people with ALS, but it is absolutely not the same. And when you're thinking about your care needs in the future, planning is really, really essential. So I just wanted to sort of amplify that message. And of course, thank you again, Shana.
Absolutely. Absolutely.
Is there anything else, Sarah? Anybody else?
We don't have any further questions in the chat at this time. So I just again want to give a big thank you to you both, Debbie and Shana. Thank you so much for sharing all of this extremely important information with us. And I also want to reiterate that this information will all be available after the summit as well. So stay tuned for more details on that. But in the meantime, I'll let you folks take a chance to grab some water or take a stretch break before our next session here at 6.